Justice Suryakant, I just want to, Your Lordship asked me that question on Section 22 of the UGC Act. Kindly have a look at the UGC Act. Volume 4A, PDF page 214.
Volume 4A. Page number, Mr. Sidhu?
Page 214, Madam. Volume 4A. Now, we just read it, Madam. The right of conferring or granting degrees shall be exercised only by a university, established or incorporated by or under a central law, a provincial law, or a state act, or an institution deemed to be a university under Section 3, or an institution specially empowered by an act of parliament to confer or grant degrees. So, as a matter of law, I can't get a degree. I can't be called a university unless I'm incorporated under the Central Act. Now, where does this provision come from?
Mr. Sibyl,
Yes.
please refer to section 23.
Yes, and that
In this case, the proviso will apply.
Yes.
And 22 may not apply.
No institution, whether a corporate body or not, other than a university established or incorporated by or under the Central Act or a provincial or a state act shall be entitled to have the word university associated with it, provided that nothing in this section shall, for a period of 2 years from the commencement of this act, apply to an institution which immediately before such commencement had the word university associated with its name.
So what happens is, in this case, because it was already a university.
Correct.
By a Central Act, is the proviso which will come into play.
Correct.
And for a period of 2 years, there was hiatus.
Correct.
They could then apply and confirm, or the UGC
Correct.
will confirm their status as a university.
Correct.
And accordingly it will proceed. In this case, because it's more than that, because they were already included in the 7th schedule entry 63.
Yeah, yeah. But I'm not in that
22,
context.
22 and 23 occupy different fields.
Yes.
22 deals with the right to confer a degree.
Yes.
23 deals with the use of the expression university as part of your name.
Absolutely. I pointed out 23, my Lord pointed out 22. But Malas, I have a different argument to make. What my Lord is saying is absolutely right. But my argument is, where does 22, 23 come from?
Just read 22(1) again. Once again.
Very well. The right of conferring or granting degrees shall be exercised only by a university established by or incorporated by or under a central act, a provincial act, a state act, or an institution deemed to be a university under Section 3 of the of an institution specially empowered by an act of parliament to confer or grant degrees. The question that your lordship should ask yourself is, where does this come from? Where is this provision? What's the origin of this provision? And the answer is 1906. Now let's go to 1906. Just go to 1906. That's to answer my lord's question. Nothing in clause, I'm sorry. Do that.
There's 2 parts.
those statutes.
Twenty-three refers to an institution which is not established or incorporated by or under a central act, provincial act, or state act. The substantive part of 23 says you cannot use the expression university as part of your appendix.
Correct.
The proviso, however, contemplated that there may have been universities earlier
Yes.
which were using the expression university,
Yes.
though they were not covered. They were not.
So you are given 2 years.
You are given. It's a sunset clause.
Absolutely.
You're given 2 years to bring yourself in conformity with the UGC Act.
Absolutely.
This case, AMU is not within the proviso for this reason. AMU had already been constituted under an act of the then Dominion legislature, and which law continued in force after the Constitution under Article 372 of the Constitution.
Exactly.
Those laws all continued post-independence.
Yes.
So it continued to be a statutory university. As a university governed by 23, it had the right to award degrees.
Yes.
That's how they acquire the right. But your argument is without this, they wouldn't have had the opportunity to award degrees. Then you would have had to go back to Allahabad University or some other university as it was before the 1920s.
Absolutely. I'm deeply obliged to your lordships. But one of the point really is, and this is a different point, and this really tells your lordship the interrelationship between 1906 and 30. Where does this come from, regulation come from? It comes from 1906. It comes from 1906 because education is an occupation. You cannot, in an occupation, do what you like.
That regulation may also be traceable to 30. For instance, in the context of Article 301 of the Constitution, which is in part 13.
But that's on trade.
That's on trade. But our court said that regulatory measures which facilitate trade are permissible under 301.
But this point was dealt with in TMA-PI. The TMA-PI said, no, it is occupation. It's not charity. It's occupation, but the surplus that you make when you run an institution must be plowed back into the institution.
Actually, it may not arise here. All that we are saying is that the power to make regulations, though expressly referable to 1906, is also implicit in 30 because 30, our court has said, 30, though absolute, cannot preclude the parliament or the state legislature, as the case may be, from making regulations which facilitate the character of the
That's
institution.
Under 1906, Madad.
As an institution of excellence.
But Madad, that's under 1906. TMA-PI says that also. That regulation is under 1906. That's why, Madad, the absolute right is there, but the absolute right has to be regulated by standards.
Yes.
The absolute right is of the choice. Means I can set up a school. The school will be regulated by the education.
That point you made yesterday, that you can set up a primary school, a secondary school, a high school, an intermediate college,
whatever.
a degree college, or
that's the choice. That's the choice. Now,
because a university is also an educational institution within the meaning of Article 30.
Yes. So therefore, but that choice can't be so absolute that you can do what you like. So you have to be you have to standardize your education in terms of the general standards set for all other educational institutions by the majority community or any other community.
And your argument really is this, which we'll hear the other side on, that if you apply the expression administer in a very strict sense, namely that there should be no outsider at all, or exclude you on the ground that, look, there are only 37 out of 180. A minority can never run a university.
No, Manoj, in fact, it is contrary to judgments laid down by this court. Because this court has said that you can have whatever secular education, it need not be only, but St. Stephen's had only 6% minority students at one point in time. Only 6%. Increased to 14% at some point in time. And then this court said in St. Stephen's, in TMFI can go up to 50%. It need not have said so. That's why our Kerala education bill is sprinkling of minorities.
Also, one very important circumstance, you can't read Article 13.
Outsiders.
Outsiders.
That's
not
correct.
minorities.
No, sprinkling of outsiders.
Outsiders.
Yeah, so therefore you could have outsiders, you will not destroy your minority status.
The object
That's
of
the
Article
point.
30, object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minorities.
Yes.
So that, you get other people also associated in the administration, it doesn't detract from your character as
That's
a
the
minority.
point. That's the point I was trying to make yesterday. Now, Malaz, in this university, just to get the facts right, this is, Malaz, there are several departments that are run. For example, All India Council for Technical Education. We have to go to them for recognition.
For medical college, you go to the
For medical college, you go there. For the dental council, we go there. For
the
pharmacy, we go there. For National Council for Teacher Education, we go there.
The law college will be governed by the Bar Council.
Correct, Bar Council. And there are different elements of administration in that. In a medical council, how will we administer at the university? We will not have any expertise. So we'll get outsiders to do it. Kindly see, Malaz, the impact of administration is again my choice. I hope, Malaz, I'm making myself clear. In some of these technical things, we'll have no knowledge, especially in a medical college. So we'll get people from outside and say, you please help us in doing this. And they may be in majority. But the choice is that I will say, please come. That doesn't destroy the character of my institution. So different standards will apply to different disciplines depending on the nature of the course that I am teaching. It is true of engineering as well.
The only difference here, we'll consider it. I mean, I'm not putting it as something against you, but a factor to be considered is that by the statute itself, you have to induct into your court a large number of people who are not minorities. This is as a matter of statutory interdict.
That's all right. But I can challenge it. Let's put it this way.
Does that alter the...
No. I can challenge it, Malaz. Kindly, that's the point that I made yesterday. If the statute interferes to the extent that I feel that my right to administration, which is the right conferred under 30, is being impeded, I can challenge it. But I can accept it. So the statute, and Malaz, we are not here dealing with the administration. This, Malaz, please appreciate, Basha never dealt with administration. Basha said, I have come to the conclusion that you are not established. The minority has not established this institute, and therefore you can't administer.
Basha went on the establishment.
So you don't have to go into that, Malaz. We really don't have to deal. The problem arose that in Basha was, the council argued that assume that I am not established as a minority institution because the administration is
established and administered disjunctively.
That was the
argument.
That was rejected in Basha. They
can't be any doubt that it's established and
administered.
You can't read that and as or.
So therefore, Malaz,
you have not. Dr. Dhawan
yes,
has also not argued
and
that.
therefore overwhelming participation of others in the administration, even if they are in a majority, even if by statute, will not destroy the character of the university. Because if I feel that my right is being impeded, I can challenge it. But I'm not. And the fact of the matter is, Malaz, if your lordship looks at the structure, and you need not in this case, because we are not dealing with that. In fact, it was overwhelmingly Muslim despite the statute. De facto. But we don't have to go into that, Malaz. We can't in a reference go beyond what your lordships are asked to decide. So, Malaz, therefore, now I was trying to show, Malaz, that all these regulations fall under 1906. The genesis and the conceptual constitutional genesis is you can't have institutions in the country without standardization in the field of education. And that standardization can only be provided by law under 19. And the law will apply to majority institutions and to minority institutions. And UGC and all other statutes are consistent with 19. The right under 30 is absolute, the choice, but the regulation is to be done under a law by Parliament under 1906. That's Malaz, the submission and the interplay of 1906 with Article 31 of the Constitution. Now, Malaz, Which page is?
417.
The context of what my lord has put in, my lord the Chief Justice. Kindly note, Malas, I won't read it. Kindly note, Malas, volume 5A, PDF 417, paragraph 41 of St. Stephen's. Volume 5A, PDF 417, paragraph 41 of St. Stephen's. And I'll read that sentence to you. The right to administer is the right to conduct and manage the affairs of the institution. This right is exercised by a body of persons in whom the founders have faith and confidence. That doesn't limit it to the minority. This is 5A, PDF 417, paragraph 41. This sentence is between placetum G and placetum H.
Page number?
417, volume 5A. It's between G and H, which says exactly what I'm trying to, let's say, consistent with my submission before your lordships.
Actually, therefore, it's important to clear a cobweb, which is that Article 30 does not mandate that administration must be only by the minority itself.
That's
In
correct.
the sense that the personnel who administer are not required by Article 30 to belong to the minority
Exactly,
itself.
exactly.
What Article 30 contemplates and recognizes is the right, namely the right of choice, the discretion which is given to the minority to administer
That's correct.
in a manner which they deem appropriate.
Correct.
Therefore, it's not that if you don't have only people of your community,
Correct.
then you risk losing your minority character.
Correct.
Because the choice is yours. You may have persons belonging to your community, you may not have persons belonging to your community.
Just to give an example, Mullah, that I have myself experienced, I happened to be in the governing body of St. Stephen's at one point in time, Mullah. Most of it were non-minority people.
The essential element of Article 30 is the conferment of choice on the minority.
That's correct. That's correct. So we are missing the link, Mullah.
It can't be read in the reverse
Yeah.
to impose an embargo that you will not have anybody save your community.
Mullah, the minority will not have the expertise to run the institution, many of these institutions. Will not have. Perforce, we'll have to take people from outside. That's why St. Stephen says, have faith and founders in whom the founders have faith and confidence. I have confidence in 10 people in the majority community to run my institution. I'll give it to them to run it. Doesn't make the institution a non-minority institution because it is founded by the minority. The inspiration to set up an institution is that of the minority. The steps taken to set up the institution is of the minority. The persuasion done by the institution to the government and the authorities is by the minority. So as long as these elements are satisfied, it's founded by the minority.
Can you come again on that? The inspiration to set up.
The inspiration to set up the institution is by the minority. The steps taken for persuasion are by the minority. The essential paraphernalia of initial funding by the minority. Persuading the authorities to accept that fact by the minority. And all these elements are satisfied in this case. So the genesis of the institution is the test. That is antecedent to recognition. All that is antecedent to recognition. And Basha says because you are incorporated, you have lost the status of a minority. This is the problem. This is the problem with Bhasha. And remember, Malats, when Bhasha was decided in 68, in-ray education bill was already there. Not referred to in Bhasha.
It is referred to.
Well, not dealt with. Siddhaj Bhai. Dealt with also. Siddhaj Bhai already there. And of course, now we have TMA Pi and other issues, other judgments. So the interplay of 1906 is fundamental. Now, Malats, as Council for Architecture, we have people giving degrees in architecture. We don't have Muslim community people in architecture. Enough. Anyway, so I'm done with this part.
Now, what remains, Dr. Mr. Sibal, what remains?
I've already said that it glossed over, yes.
What remains now, Mr. Sibal?
Now, a couple of, how the reference came is very important, Malas. I just give your lordships that. Now, as your lordship knows, give me that note. I'm just giving you.
Mr. Sibal, you're quite proficient from where you began last year on your laptop.
No, I'm very proficient, Malas. Now I'm completely, just that it'll be quicker if she does it than I, Malas, do it. No, I do it.
But Dr. Dhawan, you have not made any progression at all on that. Just, I must also tell you that there's a world of literature which opens up when you use your iPad.
Absolutely.
Which is so,
absolutely. Yeah. Not
forget
just,
forget all this.
There's also a world of abuse that opens up.
Of course.
We have to suffer, get enriched by one and suffer the other.
Myself from agreeing with Mr. Sibal.
Now, let's just see. Just these note these days. 1899, the MAO College was formed. 1899. MAO College, Old Boys Association was formed. Who is the petitioner here, Maharaj? 1899.
Old Boys Association.
Old Boys Association was formed. Who is the petitioner? I mean, I'm the petitioner here. In 1920, the Aligarh AMU Act was passed. And in fact, that's just a matter of interest, the ordinary members of the court were to be appointed by the Old Boys Association from its own members. That was as per the statute.
The ordinary members of the court
were to be appointed by the Old Boys Association as per the statute. That was the extent to which the Old Boys Association was associated. Then your lordship knows, and I will not trouble your lordship because just Dr. Dhawan has dealt with it. The 51 Act came, which amended Miller's.
Yes,
the Act was amended by the 51.
Means prior to 2020.
In the 2020 Act.
In fact, in the type version, it's been missed out.
So they missed out in the type version, it is there.
What is the next date? Were you saying, Mr. Sibal, what is the next date? I missed that.
Yeah.
What is the next date?
Then 1965, it was further amended, your lordship.
The first amendment was in
1951. Well, it's really the essential element was that Section 9, which earlier said instructions in Muslim religion would be compulsory to Muslim students, that was omitted. That's all that happened. So Bhasha.
In 1951?
Yes, in 1951.
What happens is
the instructions in Muslim religion would be compulsory to Muslim students. That was omitted. So Bhasha says nothing much happened. No real amendment. It became optional. So it had no impact on the decision in Bhasha. And then the proviso to 23 was also omitted, that only a Muslim can be a member of the court. That also was omitted. Just these two things happened. So therefore, but factually only Muslims continued, but there was a 23. That's what happened under the 51 Act. Now, my lords, in the 65 Act, which also has been dealt with, but I just tell your lordships in a second as to what happened. All powers of the court were given to the Executive Council.
Mr. Sibal, we have the reasons why the 51 amendment was moved, reasons, objects and purpose of that?
I've not investigated it. I'll find out.
Can you just tell us the 51 amendment page, or Junior can just tell you which is?
Yes, my lords, page 99 is the first, paragraph 2B, page 99.
Of volume?
My lords, can I just upload it? This we've given a chart, it's better.
Sure, but 1951.
Volume 4A, I just give it,
4A.
volume 4A at page 99 is the
1951.
Oh, your lordship wants the 51 Act or the 65 Act?
51 Act.
51 Act, the first amendment is the section 9 amendment is volume 4A at 90, paragraph 2. At page 90, paragraph 2,
Yes.
which omitted section 9. The second amendment of proviso to section 23 is 4A again, page 93, paragraph 17. 4A again, page 93, paragraph 17. So those are the two amendments in the 51 Act. The religious instruction was made optional for Muslims, and can I just airdrop it, Mullah? It's just a note. You just do it now so that it's easier. We've done it, Mullah.
51, it shows.
Because it's. Yeah. I know that. On the screen.
What?
That's right. Now, Mullah, I just point out. So this was on the 51 Act. Then the 65 Act, Mullah, what did it do? In volume 4A, page 99, para 2B, the powers of the court were given to the Executive Council. This is volume 4A.
This is also volume 4A.
4A. All is in 4A. Page
Powers of?
99.
Powers of?
Powers of the court, erstwhile powers of the court were given to the Executive Council. That's at page 99 of volume 4A, paragraph 2, small b. And then statute 8, that is members of the court, was amended.
Statute?
8, which is members of the court, was amended. That's in 4A at 102. Page 102. And then the other was all existing members of the court and executive council were ceased to hold their office. That's at page 105, volume 4A again, paragraph 10. Right. This was an emergent situation, and This then in 65 was challenged, not by AMU, not by anybody else, challenged in a PIL petition, which resulted in Basha in 1968. The Old Boys Association were not parties, AMU was not party.
This challenge, I think, include 1951 amendment also.
Yes, yes.
Both.
But Basha said 51 really is not too relevant. 65, both were under challenge. What happened thereafter, and this is very interesting, brothers. During the court, when this came up in Parliament, and at that time, Mr. Chagla made a statement, which I give it to your lordships. That's in volume 4C. Yeah, 4C 1325. That's important for us.
4C page 1325.
25.
Chagla is the Minister of Education.
Yes, correct, Mullah. At 1325, volume 4C.
बंद कर दो एक मिनट।
I didn't forget it.
Because Aligarh Jung was then the Vice Chancellor. There was an agitation because the institutional, remember, there's a school there. There's also institutional reservation that was reduced from 75 to 50%. There was a huge agitation all over the country. And the Aligarh Jung was injured in the process and he was manhandled. So therefore, as a temporary measure, they sort of said, we must stop this maladministration. That was the reason for this. But kindly see, at this, at volume 4C, page 1325. What Chagla says, in Parliament. That's it. My lords have?
Yes.
Now kindly see, Mr. Speaker, on the right-hand side. As we all know, we are facing a very serious crisis just now. There is aggression, there is undeclared war. We should do everything in our power to maintain communal peace and harmony. We should not say a word which will interfere with the harmony which exists and which should continue to exist. Today, we should think of ourselves not as Hindus or Muslims, but as Indians, one and all. I wish, this reverberates, in India as we stand here. Now, I am a great deal in agreement with what Mr. Mukherjee said. I have said this before and I repeat it. I repeat it with all the emphasis I possess that this bill will not in any way affect what Sri Mukherjee chooses to call the special character of the university. The Academic Council has not been interfered with. This bill does not touch the academic studies in the university. The academic studies will go on as they are. I also reiterate what I said before, that this is a temporary measure. Kindly note that. An emergency measure, and a permanent bill will be introduced as soon as possible, if possible in the next session. Then next he says, it should be a symbol. Oh, sorry. It should be a symbol. It should be a symbol of Muslim culture in the context of secular India. It should be an example to the rest of the world how different communities can preserve the glory of Aligarh. I know it has made a great contribution to our academic life, our scholarship, and our nationalism. I want to assure this House that I have brought in this ordinance and the bill as a temporary measure in order that Aligarh should be strengthened and should become a modern progressive university, that it should be a shining light not only in India, but abroad of our great composite culture.
What was Mr. Shamaprasad Mukherjee's objection to this? When he says Mr. Mukherjee, that was
This is 65, sir.
H.N. Mukherjee.
No, he was back.
H.N. Mukherjee. H.N. Mukherjee.
When did that?
Another, some other Mukherjee, not Shama Prasad.
11 itself.
What was the objection actually?
311, Malas.
311?
1311, not 300.
1300.
What was the objection actually?
Yes. There is a misgiving in many Muslim minds, whether rightly or not, is a different matter, that the special character of Aligarh is likely to be violated. That's the objection. 311.
This is Hirendranath Mukherjee.
1311. Because what happened was the election, executive council was backed by the nominees of government. Would have been packed by, because that's what 65 allowed that to happen, because everything was abolished. So there was a misgiving that if you pack the executive council with nominees of the government, what happens to the character of the university? So in this context, there is a misgiving in many Muslim minds, whether rightly or not is a different matter, that the special character of Aligarh is likely to be violated under the new arrangement. Shri Chagla has been a judge, and you, sir, also have been in that elevated position, and you know of the judicial maxim that justice should not only be done, but it must also appear that it is being done. It is the government's responsibility to show Muslim opinion all over the country that this apprehension is wrong. I know that Shri Chagla is right insofar as he is trying to put a real secular democratic complexion to Aligarh University, but if this misapprehension has arisen in the minds of many people, about all of whom we cannot be sure that they are reactionaries,
He was in support of Justice Chavez.
Hmm. Community.
When your lordships are on that page, if your lordships can see the initial part of Mr. H.N. Mukherjee's at page 1312. One page possibly is missing, my lord. We'll place it when our turn comes.
1312. Yes, it's there.
No, one further page. Anyway, I'll point out.
Just since we were on this, we are reading at 1312. Which part do you want us to read, Solicitor?
The initial debate, my lord, initial speech, or my lord, initial address
It's there.
of Sri
right
H.N.
there.
Mukherjee.
1311.
Yes.
1311 is also there.
And
On the
Raja
left side.
Mahendra's Pratap Singh have all been brought up in Aligarh. Besides, Aligarh is not merely a foundation set up by the minority community. It is a foundation which the whole country has taken to
Fine.
its heart. And that is why today we find so-and-so non-Muslim students and so-and-so foreign students in Aligarh. The reputation of Aligarh is not merely the responsibility of Muslim community. The reputation of Aligarh is something which the entire country has got to look after.
I
This
agree
is
entirely.
precursor to entry 63. But
Oh,
there is one
one
more
second.
passage we'll place
That's not good.
when our turn comes.
Read that portion, last portion at page 313,
Last portion is 1313.
1313,
Yes.
for that purpose.
We have in regard to small matters, that's the one. We have in regard to small matters here and there. Let us forget what particular things we can bring up against government on particular issues.
For that purpose, I want to.
For that purpose,
On the right side.
on the right side,
Or you can start from little above also, that will.
1313. Yes, I'm reading that. Yes.
For that, says.
For that purpose, I want Mr. Chagla to reiterate more emphatically some of the assurance he has given and to seek to remove persistently by repeated effort the misgiving which continue in the minds of many Muslims in our country, all of whom I am not ready to brand as reactionary, that this legislation is going to hurt the Aligarh institution and to hurt the interests of the country. And Mullahs, there is no doubt, Mullahs, that this institution is not just for minorities. It is founded by minorities. It's for India. It's all encompassing. We are at the moment, whether it was founded by the minority or not, that's the question. In fact, if your lordship looks at this page, kindly see 1311, kindly see the last two paragraphs, we have swallowed a bitter pill, the principle of nomination, because government could have nominated. And all that kind of thing, the exclusion of representative of teachers in the court and the executive council and so many other items into which I need not go, but we have swallowed a bitter pill only for the time being so that the regular medicine follows a little later. I wish also to say that it is time when we discuss a matter of this sort that Muslims and Hindus and all, we remind ourselves of the role of Aligarh Muslim University in the context of the composite culture of our country. Aligarh has been a symbol cherished by Muslims, no doubt, more than any other people in India, but it is cherished also by the rest of the Indian people. In the traditions of Aligarh, there have been many bad things, no doubt about it. Good and bad are mixed together as far as the traditions of Aligarh are concerned. So, Malad, it represents composite culture. It is founded by the minority. It's an institution of excellence. There's no doubt about it. But Basha says...
Only one interjection, Malad. Only one. Something is missing, therefore. You have placed on record the proceedings of the Parliament, Lok Sabha, dated 3rd September 65.
Yes.
And 6th.
Yeah.
There is one proceeding before that, that is 2nd September, the day prior,
Okay.
which I have quoted, my lord, in my written submissions, verbatim, at page 111.
Okay. But read it so that I'm also sort of educated.
It's, I'll read it, and it's in 111 of my written submissions.
Please, if you read it.
Which I believe should have been placed.
Yeah.
Lord, your lordship gets, my lord, my written submissions, page 111.
Volume 2B.
Volume 2B, I'm sorry, volume 2B, page 111,
You're referring to which date, Mr. Mehta?
2nd September
2B.
65. Well, what is placed is from 3rd September,
No, we'll see 111. I've got it.
but there is one which is missing, my lord. I am sure inadvertently, but this is what.
Have you placed the 3rd September inadvertently, not placed it?
2nd September.
Have you placed 3rd September inadvertently?
Yes. We placed everything.
Yes.
Please. Speech by Justice retired MC Chagla, then Education Minister. Your lordship gets, my lord?
Page 111.
Yes. 111 at the foot.
I'll just see it.
I'm sorry. I'll wait till Mr. Sybil finds.
No issue at all. Yes. Now,
Speech by Justice retired MC Chagla, then Education Minister. My submission to this House is that Aligarh University has neither been established nor is being administered by the Muslim community. It is not a minority institution in the sense in which Mr. Anthony suggests. That is Frank Anthony. I will give him the reasons. You had first the Muslim college which was founded by Sir Syed Ahmad. Sir Syed Ahmad has asked the British government.
This is entirely contrary to what he says, Malad, on the 3rd of September.
Can't contradict what he
For which we have the debate.
He is introducing the bill as an education.
One second.
Anyway, my lord, I'll in my turn.
Not entire.
Do we have the entirety of the discussion of the 2nd of September? Where is that?
We will place it, my lord. We have quoted it, but we'll place it.
When have you quoted the 3rd September? And 6th September?
It's on record.
Maybe inadvertent.
No, it's on record, therefore not quoted.
I see.
This was not on record, therefore it is quoted.
Right.
But I'll place it, my lord.
So if it's on record, it's on record. Then on 2nd September, it's also on record.
Second,
Anyway,
it's
Malad,
not on
we are
record.
not concerned with this. Malad.
It's a small issue, but if we look at it that way, but 2nd September, according to me, is an important piece of, my lord, parliamentary debate, which is not on record. I'm not, my lord, imputing any motives. That's all.
Well, your lordship notices Chagla says quite the opposite on the 3rd of September.
That's true, but we can't.
And he is the mover of the bill also. So how does it take the matter further? I was only indicating how the reference came about, Malad. So I'm just only for that purpose. And Malad, what's
Is on.
See, when did the Indo-Pak War break out in 1965?
5?
We'll check up and see, my lord. Often it may not be an accurate statement.
I think.
Both of us will check up and see.
Hi, Mr. Chagla says in the 3rd September that we are in a situation of an undeclared war. That part which he says.
Undeclared war has continued from beginning till date, my lord. But I'll check up, my
The
lord, what
first
is the
way-
context in which he says?
Because that sheds some light on the purpose of the amendment then.
Correct, correct. That, in what context, my lord, it was?
And this amendment,
We will check up, my lord, and we'll correctly assist you.
Malaj, in fact, the council, the executive council was 100%
So
non-Muslim.
it's on record, my lord. This,
100%.
my lord, I'm
That
sorry.
was the fear, that you are changing the whole character. They were then reduced later to only 3 to 5.
My lord, we have placed on record the entire debates, my lord, with our documents, my lord. That is, my lord,
It's okay, it's okay.
2F, it's not okay. You can't miss one important page. My lord, it is page 224 to 365.
I say, we shouldn't get into all this. The court has to decide whether it was founded.
Only saying, you can't selectively place the
But
parliamentary
have you
debates.
quoted
That's
the
all.
September 3 in your note? You
Sibyl-
haven't.
Sibyl, at the end.
What's the point of all
At
this?
the end, Mr. Chagla says, I say that this institution was not established by the minority, nor is it being administered by the minority community. That is the legal position as far as Article 30 is concerned.
Yeah,
So it appears the position of the then law minister, the Minister for Education,
Yeah.
was that this was not an Article 30 institution.
correct. And the government defended that position in Basha. The government defended that position in Basha. Correct, Malaj? Then came the 81 Act, and the government is not defending that position. Malaj, if there's a parliamentary, that's why I made that comment yesterday. If there's a parliamentary act, government has to defend it. It can't say no. We're also defending the act in 65. Once you make the act, Malaj, you change it, you will have to say. What choice do you have? The minister has to say. If we move a bill, Malaj, as a minister, we'll have to defend it, no? And we are moving the bill saying that the executive council can be nominees of the government. And if they are nominees of the government, Malaj, then the whole character of the Muslim of the institution goes. So the minister has to say this. So that doesn't answer the question. The parameter, why and how it is a minority institution has to be judged on the parameters of the law laid down by this court.
Yes.
When opinions of court can be wrong, certainly opinions of ministers moving a bill can be wrong, Malaj. I mean, there's no sanctity to that. The sanctity is to the law and to the constitution. That is why, Balaj, because of these provisions, it was challenged. This 65 Act was challenged and upheld. And Mr. Daftari argued for the government, saying that it is right. Surely, Malaj, the minister's contradictory opinions can't be the basis of a judgment of a court. That certainly is settled law now.
Right. You can't quote one part and not.
No, you're right. I'm not disputing that. I'm not disputing what you're saying. You will read the other part and I will read this part, right? Yes,
Based on
that's all right. It is already on record.
It's not on record. We have placed the entire thing on
I
record.
see, but you haven't quoted it.
Anyway, let's
Send it as you haven't given it to us.
No, it's there in Volume 4F.
We don't have it.
4F.
We don't have it. It's not uploaded.
It's there in the common file. Your nodal council has it. 4F. Let him say it's not there. They
We
have
don't have
it since then, since long.
No, Malas, kindly let's move on with the.
Yes,
That's
Yes,
the better way. That's the way.
Debate is not in question. I'm just trying to give the. Malas, let's go back to what I was saying, Malas.
Sorry, 72 amendment,
Yes,
that brings out, what exactly happened. It appears that there was student unrest on the
yes,
campus.
yes,
At that point, they brought in a temporary measure.
yes,
The idea was to bring both Aligarh Muslim University and Banaras Hindu University at par in
Yeah.
terms of the statutory provisions.
right,
UGC appointed a commission chaired by Dr. P.B. Gajendra
yes,
former Chief Justice of India, to go into the functioning of AMU. That Dr. Gajendra submitted his report. We may have we may want to look at the report which
Sure.
was submitted by Dr. Gajendra
sure,
on what did the report really indicate.
right,
Following which, by the 1965 amendment was always intended to be a sort of a pro tem amendment
That's
until long-ranging amendments were brought into the
Right.
provisions of the
Right.
statute.
So then, Malas, between 65 and 81, I go back to my list of dates, Malas, the point of, which is that volume 4.
See if you look at.
Note, yeah, what,
the essential-
yes. I'm coming to. So, Malas, we come to 1965 and the decision in 1968. Then between 68 and 81, there was a movement to protect the rights of Aligarh Muslim University as a minority institution. And then the 1981 Act came. So you have a hiatus between 65 and 91. 68 and 91.
Just give us the
81,
page
sorry.
number of the 1981 Act so that we'll have it all in one place now. Volume 4A,
4A, volume 4A, Malas,
page.
page 147. And Malas, in that context, if your lordships don't mind, that judgment is not on
That's
record. Yeah, there's a judgment of this court in 1998, 6 Supreme Court cases. Maybe they can get it. No, they could send it. 1998, 6 Supreme Court cases, 674.
That report might be relevant.
Yes. Yeah, good. Yes, paras 12. Yes. 11, 12, 13.
It is there on this.
I got it. This court which is on your lordship's screen, Malat. 1998, 6 Supreme Court cases, page 674. Kindly come to 679.
679, Pijay.
679. This was in the context of a minority school, Malats. Malats, minority school in paragraph 11, Malats, your lordships will see, is defined in 2(5) of the Act. Minority school means school of their choice established and administered or administered by such minorities as have the right to do so under clause 1 of 30. Counsel for both sides conceded that there is no provision in the Act which enable the government to declare a school as a minority school. If so, a school which is otherwise a minority school should continue to be so, whether the government declared it as such or not. Declaration by the government is at best only a recognition of an existing fact. This is very important. Article 31 of the Constitution reads as such, I won't read it, Malats. When the government declared the school as a minority school, it had recognized a factual position that the school was established and is being administered by a minority community. The declaration is only an open acceptance of a legal character which should necessarily have existed antecedent to such declaration. Therefore, we are unable to agree with the contention of the school that the school can claim protection only after the government declared it as a minority. We are not dependent on the declaration, Malats. It's what happened antecedent to the declaration that will determine whether it's a minority institution or not. So whether the minister says it or the statute says it, none of that is relevant. What is relevant is the factual position existing antecedent.
came 81.
And then you go back to, yes, this. We come to the 91 Act, Malats. Your Lordship is aware of that Act. Then comes, Malats, on 26th of November, 1981, there's an order passed in Anjumane Rahmania, which is writ petition 547, 554 to 57 of 81, which is referring Basha's judgment to a 7-judge bench. That's on November 26. This is important. That is November 26, 1981. The 1981 Act was on December. What's the date of 22nd December 1981. Just 1 month after this. Yes, was 22nd December. Now, let's kindly look at that order of Justice Fazal Ali. Volume 3A, page 209.
Fazal Ali J was in a bench of 2 or bench of 3?
2.
2 referred the matter to 7?
Yes, this is.
That's one of my contentions.
No, that's all right. You can. Yes, 3A, Mallas, page 209.
Yeah, Chief Justice.
$209, volume 3A. Kindly have a look at that. Kindly note, it's writ petition 54 to 57. It will have some bearing. This writ petition 54, 57 has some bearing, so kindly let us note that. Let's kindly, if I can read that order. After hearing counsel for parties were clearly of the opinion that this case involves two substantial questions regarding the interpretation of 30 of the Constitution. The present institution was founded in the year 1938. That's the other institution, and registered under the Societies Registration Act in 40. The documents relating to the time when the institution was founded clearly shows that when the institution was established mainly by the Muslim community, but there were members from the non-Muslim community also who participated in the establishment process. The point that arises is whether Act 30, Article 30 it should be, not Act, or Sub-Article 1 of the Constitution envisages an institution which is established by minorities alone without the participation for the factum of establishment from any other community. On this point, there is no clear decision of this court. There are some observations in Basha, but these observations can be explained away. Another point that arises is whether soon after the establishment of the institution, if it's a registered society under the Societies Registration Act, its status as a minority institution changes in view of the ward principles laid down in Basha, because then it gets merged, but is incorporated. Even as it is, several jurists, including Sirvai, have expressed about the correctness of the decision of this court in Basha. Since the point has arisen in this case, we think that it is a proper occasion when a larger bench can be considered the entire aspect fully. We therefore direct that this case may be placed before the Honorable Chief Justice for being heard by a bench of at least 7 judges, so that Basha's case may also be considered. And the points that arise in this case directly as to the essential conditions or ingredients of the minority institution may also be decided once for all. A large number of jurists, including Mr. Sirvai, Learned Counsel, Mr. Garg, and Learned Counsel for respondents and interveners have stated that this case requires reconsideration. So therefore, liberty was granted. So this happened, Malat, in November 81. The act comes on December 22nd, 81. In the meantime, on the ground, nothing has changed, Malat. When Chagla made that speech in Parliament, he didn't implement the 65 Act as that was sought to be done. He didn't do it. Only, instead of all it being packed, only 3-4 members remain of the non-Muslim, of nominees of the government. Then, that is the Old Boys Association, which was set up in 1899. Sorry. Started a whole movement that, look, this is all wrong. This is all wrong. You must have an act. That's how the act came into being. And I don't want to digress into any other issue, but the fact is that this is a pre-Constitution Act. It's a 1920 Act. Without going into usurpation of judicial power, that's all, according to me, an irrelevant issue. Under 372, an act can be repealed, altered.
One act.
Yes.
Did that have the effect of, therefore, then nullifying the 65 amendments?
Yes. Yes. Absolutely. So this whole argument of usurpation, the Constitution gives the Parliament that right. But I don't want to argue it because it doesn't arise in Basha. But since,
Basha involved a challenge to the 65 amendments.
That's right. And 51.
And 51.
Yes.
And the 1981 Act then restored the position by, I don't know whether it destroyed
it didn't exactly restore. It was a new legislation.
But it nullified the effect of the 1965 Act.
That's correct. But that doesn't matter because the 372 gives the power to Parliament to alter a law.
If we, will it be correct to say?
It seeks to nullify the judgment.
No, one.
No. That's not true.
I'll show. I'll show.
Will it be correct to say that in case we overrule Basha, then the challenge to the 65 amendments will come into the foray?
No, Malat. The point I'm making is somewhat different, Malat. We are challenging Basha on the day when it was decided. Therefore, none of this is relevant, according to me, because the reference is only whether Basha was rightly decided on the day it was decided. That's the reference. But all these matters are now being brought in by the other side. All these matters saying it's an institution of national importance under. That's right. I know that. I know that. To do is whether Basha is rightly decided or not on the parameters of the law under Article 30. What your lordships are not asked to decide. Now they have brought in entry 63. It was not argued in Basha. Are we to argue something else now? They brought in statutes that are minority statutes that are normal institutions that are now incorporated under the National Minority Commission Act. Are we to look at that? That's all irrelevant. Wholly irrelevant. This is a decision of 1968 based on an act of 1920, which your lordships are asked to decide whether it's right or wrong. Otherwise, there'll have to be pleadings because he has made some averments which are completely wrong. But you can't have pleadings in a reference. He's giving all kinds of examples. Land was given is completely wrong. But we are not into that. That's why I'm not arguing any of that. That's why I'm not even meeting that argument. But that whole argument is sought to be diverted to issues which are not before Basha, issues that don't arise under the 1920 Act.
All right, what else?
So, I'm quickly trying to go through it. So, no. Then what happened was, just kindly, I'm trying to finish as quickly as possible.
Mr. Civil, just one simple question.
Yes.
Did Dawoodi Bohra make it applicable prospectively, the principle laid down in Dawoodi Bohra, or is it applicable retrospectively?
I'd have to, I don't want to answer that question. I don't want to answer that question right away. I don't want to answer that question right away. I will certainly, So, what happens thereafter? And that's then comes then comes TMA Pi. Now, this 54 writ petition 54 to 57 is tagged on to TMA Pi before 11 judges.
The order also says that.
That's right. So, this whole argument that you couldn't refer it, 2 judges could not refer it, of course, the principles of law that time are different. But be that as it may, it was tagged on before 11 judges. Writ petition 54 to 57, you'll find that order, in 3A, page 216. Two one six. 552, sorry. Yes.
In 5A.
In 5A, 552, first line. Sorry, Yeah, but I will then now give the reference after this Google reference.
What specifically says
Court rules, Malad. It says, where in the course of a hearing of any cause, appeal or other proceeding, bench considers that the matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for the hearing of it. Rules Order 6, Rule 2.
Rule 2. And Rule 1 anyway preserves the power of the Chief Justice.
That's correct. And Malad, even Justice Gogoi's reference was 3 judges, Malad. Even Justice Gogoi's reference was 3 judges. So this objection that, it can't be referred, Malad, is all.
And though Chief Justice Gogoi was sitting on the judicial side,
Yes.
as Chief Justice, his powers are
His
preserved by
powers
Order
are
6
there,
Rule 1
yes.
to constitute
And then
larger
TM
bench.
If bench consists of the Honorable Chief Justice, it can be.
Why can't 2 judges say refer it to 7 and refer the matter to the Chief Justice?
Anyway, but I'll not reduce the debate to that level.
Ah, but
I'm not going to
taken
raise that
that
objection. We have addressed your lordships on merits. I will also have
Correct,
lordships.
because initially he did, therefore I.
So the matter is too important for us to really
Yes,
rest the judgment.
exactly.
on it.
Yes, yes, what I initially
So,
said
we
was,
can't be oblivious to the fact, reference of 1981,
certainly,
tagged on to 11 judges,
certainly. But I'm,
left open in TMFI,
Yeah.
then noticed in Justice Gogoi in the referring order of 2019. But Mr. Sibal, there's one which
One
we
thing,
must
Mr.
also bear in mind,
Sure, sure.
that when Chief Justice Gogoi's bench made that reference to a larger bench in 2019, unless
I have not raised it.
Then,
I have not.
when the pleadings are incomplete, then there are no pleadings to this effect.
But we have a performance, we have a parliamentary amendment of 1981.
Correct, but there are no pleadings for the. That
I will show from
how,
the record.
how will it be decided?
It's whatever I have said is a part of the
Clear on
record.
one thing, Malad.
Only one. Give me a minute just to answer the court.
One.
I have not raised that technical point. Initially, I said that the scope of reference is not redeciding Basha on facts which are concluded. The way they are arguing. That's what I have said.
No.
I have
In
not-
fact, Malad, he said that's an inter-parties decision. It cannot be altered by a bench. That's his argument.
That's
in the written
But not
summation.
this reference could not have been made.
One
as-
second.
Yeah, Mr. Sibal, Mr. Solicitor, we are in a combination of 7.
Yeah.
We decide a constitutional matter. Perhaps it would be inappropriate for us to look at facts for deciding the minority character.
Yes.
Who gave how much land,
Yes.
whatever is already on the record, what was brought on the record in Badshah,
And Allahabad High Court, whatever is in the record from the Allahabad High Court, no problem.
So when we hear Mr. Farasat's de jure versus de facto argument, we must also keep at the back of my mind that this is a constitutional court
Yes.
sitting in a reference of 7.
That's right.
So we really have to, in that sense, confine ourselves, and perhaps there's always a temptation to try and resolve everything forever, but it's difficult, and we should be careful about doing that in a combination of 7, particularly in the absence of test facts.
My request is whatever pleadings are available in the Allahabad writ petition should be taken into account. But none of what he has
No,
pleaded
it
now
was
is
a
part of
32
it.
petition.
Sir?
Basha was a 32 petition.
No, I'm not on that. In the Allahabad High Court, Malad, I was trying to complete the list of dates. Then this matter, Malad, 81 onwards, the act came. Then TMA, 24 years, we were granting decrees. Then in 2005, that's the next date, Malad, 2005, Malad, there was a 50% reservation for MD, MS students. That was challenged. That resulted in the Allahabad judgment, where the judge said, Basha has rightly decided, you are covered by Basha. It didn't go into anything else. So that was not strictly Malad before the court. The issue was only 50% reservation of the Muslim.
Basha upholds the 1951
Yes,
and the 65 amendment,
yes,
right?
yes.
the Allahabad High Court sets aside the 1981 amendment
Yes.
on the ground of Basha.
That's correct.
Now, two questions will arise before us. Suppose we hold that we accept your, for the testing the argument.
Yeah.
Suppose we accept your argument and hold that Basha was wrongly decided.
Right.
Basha upheld the 1951 and 1965 amendment.
Correct.
What would be the consequence of our coming to the conclusion that Basha was wrongly decided on the amendments which were in challenge in Basha? Second, if we hold that Basha was wrongly decided, then what would be the impact of that on the Allahabad judgment? The Allahabad judgment dealt with a challenge to the subsequent amendment.
Yes.
Right?
Right.
Now, if Allahabad has relied exclusively on Basha.
Right.
Now,
Correct.
if we come to the conclusion that Basha was wrongly decided,
Correct.
it would immediately impact upon the judgment of the Allahabad High Court.
Correct.
And therefore, the validity
By the other bench.
actually, if Basha is upheld,
Yeah.
then
Then
the
also-
validity of the 1981 Act becomes subsidiary.
That's right. That is
Because the 81 Act purports to restore the minority character
yes.
of the institution.
Yeah.
If it is held not to be a minority institution,
Restore,
right?
first, not restore, confers, according to.
Right.
It
Whatever.
was never there, it confers.
That's
Basha says it's not there. so
That's
it
right, but
confers.
that's why we are dealing with Pasha. That's the point. You can't rely on Pasha to decide on the 1981 Act.
So ultimately, our decision on the validity of Basha
Yes.
would impact upon not just the amendment, but it also has an impact on the Allahabad
Correct.
judgment.
And therefore, Maharaj, that matter will be decided by another bench. So your lordships are not going to go to all this. Maharaj.
Mr. Simple, even on, suppose we even,
That's what I was trying to tell him actually.
even if you overrule Basha on the two legal principles, on interpretation of establishment and administration,
That's right. But Maharaj, the 81 Act will come in the meantime, Maharaj. Yeah. Correct.
and in case Basha is overruled, then 81 amendment, they may withdraw their appeals. There's nobody.
We don't know what's
pursue
going to
it.
happen, Maharaj. Litigation is part of the culture of
It's
this.
quite clear, it serves no purpose then
I
for.
know, Maharaj.
serves no
Your
purpose.
lordship knows it, even when in litigation there is no purpose, still there is litigation.
Why?
Only.
Your lordship experiences it every day. So Maharaj, Dr. Dhawan will live to argue the next case, Maharaj. So Maharaj, these submissions are being only divert the attention of the court to issues that are not before it. Yeah, of course, everything's up.
That 81 amendment be also examined because
No,
they are not several.
Not in a
They are
reference.
not comfortable with that amendment.
No, we
defend
are
that
comfortable.
amendment.
It's not referred.
Will definitely have a bearing on the Allahabad High Court judgment, definitely have a bearing. Which
The
we
reference,
look at.
the reference has emanated from that 81.
So to say that that will have, that has a direct bearing.
The
Rather than
reference
people
is in
not
that
decide Basha, completely decide what the Allahabad High Court has decided either.
Not either.
So, if we overrule Basha and say that AMU has a minority status in view of,
Yes.
the
is not removing the valid, is not a validating act removing the basis of the
No difference.
overruling
No difference, Mr. Kaur, no difference at all, because once Basha is declared to be in bad law,
Right,
the position as it was before Basha in law would have to be examined. That's
right.
it.
But as my
And therefore, 81 amendment, the reasoning of the Allahabad High Court that the legislature is directly overruling the High Court no longer remains.
that is the second part. The first part is Allahabad High Court relies on Basha.
Actually, that's appears to be.
Allahabad High Court directly relies on Basha to say what it says. And then in addition says that
Mr. Kaul,
has to overrule.
Mr. Kaul, Basha denies minority status to
Right,
AMU.
right.
The 81 amendment sought to, as a solicitor, I'll put it in from your point of view, the 81 amendment sought to confer the minority status. They say that this was declaratory. We will have to decide that. Now, the fact of the matter is that if we come to the conclusion that Basha was wrongly decided,
Right.
the immediate impact of that would be that the denial of minority status to AMU was wrong. We don't agree with the reasons on the basis of which Basha denied minority status to AMU.
Right.
In which case, the reason why my brother is putting that to is this. If we overrule Basha, then the only basis for setting aside the 1981 amendment was that Parliament has merely nullified the judgment in Basha without taking away its basis. If we come to the conclusion that Basha was wrongly decided, that ground of challenge with the Allahabad High Court ceases to have any relevance.
But it has a direct impact on the decision.
Undoubtedly, but
All that I said was.
the whole postulate of the Allahabad judgment
Yes.
is that Parliament could not have, without taking away the basis of Basha,
Yeah.
overruled it by a simple declaration that they did by amending the definition.
Right,
But if we go to the source, which is Basha,
right,
and come to the conclusion that Basha was wrongly decided,
right.
the basis of the Allahabad judgment itself is taken away.
I started by saying.
That's right.
That what Basha is decided in has a direct impact on the Allahabad High Court judgment.
So ultimately, it all boils down to whether Basha is correct or otherwise.
That's all that I'm saying, brother. That's all that I'm saying.
That's a core issue.
That's the point.
Mr. Paul said. In the High Court, reliance was squarely placed on the 81 amendment because they had a 2005 decision which was taken after the 81 amendment saying that they are giving reservation. That was the cause of action for the writ petition before the High Court. In the process of defending that decision, square reliance was placed on the 81 amendment. Therefore, the High Court went into it, looked into the factual finding in Basha saying that it is not a minority institution. Now, therefore, today it can't be that much. The telescope is put back as it were straight away to 1967 and then said, decide Basha in a vacuum, whether it's right or wrong. The difficulty is in the process of doing that, 81 is relied upon, 72 is thought to be relied upon. Please ignore 81 for a minute, Manoj. 1972 is thought to be relied upon. 72 is immediately after Basha. So with all this, I would respectfully submit when there is a reference made, the matter proceeds on the basis that the entire matter is before the court. One more aspect, Manoj. Please see the reference order. Reference order, as what rightly fell from my lord the Chief Justice, does not confine it only to the question of Basha. He talks about the NC-MEI Act of 2006 as amended in 2010. The question is then, will the 7 judges then completely excise from the consideration that act also? Now they are relying on the 2006 Act also as amended in 2010. So these are, in my respectful submission, my lords, issues where it has to be a holistic picture.
We are not concerned directly with 2006 or 2010 Act. That's not the subject matter of Basha. One. Number two, that has not been examined by any 2 judges bench or 3 judges bench.
I follow, my lords, but then in the reference
That's
order.
it. That's it. Now, directly making a reference over here without there being a direct, yes, what does the second order does of Justice Gogoi, Chief Justice Gogoi does is, it just narrates the history, what has happened. The questions which are there are the ones which were already.
No, not necessarily. With respect, my lords,
It will have some bearing. Why Justice Gogoi refers to it, and that is why we started by saying the scope of reference in our own terms. The entire reference, including Justice Gogoi's order, was about conjunctive or disjunctive. Yashpal in the NSC-MI order, which Justice Suryakanth pointed out yesterday, the issue arose was, is it established or incorporated in the UGC order? Now, there Yashpal answered it by saying it's and. The 2010 amendment which was brought about later to the NSCME Act also said it's and not all. In that context, Justice Gogoi, while dealing with the history of what has happened since right from the beginning, the only issue for 50 years, no decision ever questioned Pasha's decision on the individual finding on administrative or establishment. The only question which is being raised repeatedly, like Manya downwards is establish and incorporate disjunctive or conjunctive. And I'll show that in my third comes my notes. That's why this Gogoi, in the reference order of 2019, categorically relies on Yashpal to say that Yashpal, NSC, NCMI, and UGC dealing with the issue of or versus and, not on the issue of my AMU being a minority as administered or established, only on the adjunctive and conjunctive issue.
Mr. Cole, the principles laid down in Yashpal will definitely have to be referred to while examining Basha. One. Two, the subsequent amendment which has direct bearing, that is 1981 amendment, say, put it otherwise. I think you can reformulate what you are probably trying to say. If the 1981 amendment is approved by the 7th judge bench, is upheld by the 7th bench, then challenge to Basha becomes academic.
That's, I bowed down, Malad.
Then Basha, then examination of Basha also does not survive.
Grateful. But all that I'm saying is this whole reference
Probably this is
to
what
UGC,
the issue will arise.
NCMEI,
From that angle,
Yashpal
Mr. Sibal,
was
because
not
I'm
nothing in
sorry.
Justice Gogoi's order.
I'll answer that
It was all
straight away.
dealing with adjunctive versus
Alex,
conjunctive.
let's hear Mr. Sibal now. We have to wrap up.
Yeah, so
Only one line.
because all this time has been.
Only one
Sibal, yeah.
line, if your lordship.
Now, let's complete Mr. Sibal's argument. Is almost.
I'll
done.
answer
Yeah,
it straight away, Malad.
Yeah.
Assuming for the moment your lordship decides that Basha is wrongly decided. Let's assume, Malad. What is the consequence? That I was a minority institution at the inception.
that may not expressly or impliedly approve the 1981 amendment.
Forget 1981, Malad. Your lordships will give a declaration that I am a minority institution. That's all. Forget the 81 Act. What is it? Your lordships can't change the nature of the minority institution if you say that Basha is wrongly deciding. That nature will not change, Malad, under the 1981 Act. 1981 confers something, what your lordships would already have decided. What are we talking about? So let's be clear on what the lay of the land is. If Basha is rightly decided, then the question arises whether the 1981 Act
Whether did it take away its basis or merely nullify the
exactly, then only it arises, not otherwise. Because 81 will not change the status, Malad, of the minority institution with a declaration that Basha is wrongly decided. Therefore, Malad, all this is a red herring.
Right. What more now, Mr. Sibal?
I've been trying to finish, but what can I do, Malad?
There's always time out by the judges, so you have to always factor that in. So, how long more now, Mr. Sibal?
Not very long, not very. I'm just, Malad, trying to, then I'll finally come on Basha and that's it. Nothing more than that. So, Malad, now the reference. If your lordship,
Yes,
you want
the reference.
let's read the reference of Justice Gogoi. That's at Malad's volume
What is the date?
3A. Date is Malad's
26 September.
12th of
Of 19.
February 12,
No, that's a Google.
2019. February 12, 2019, volume 3A, page 216. Read it, finish it, yeah.
In which case,
Sorry, Malad?
the reference order
Yes. In
is in Allahabad.
in AMU, Malad. AMU versus Naresh Agarwal. And all other connected matters. That's the challenge to the High Court order. Now kindly see, Malad. in Aziz Basha, the court, it is to our mind quite clear that 30 sub-article 1 postulates that the religious community will have the right to establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though the religious minority may not have established the institution, it still have a right to administer it if by some process it has been administering the same before the Constitution came into force. We're not prepared to accept this argument, and I'm not arguing it. It's completely wrong, Malas. The article, in our opinion, clearly shows that the minority will have the right to administer an educational institution of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by somebody else, any religious minority would have the right to administer it because for some reason or other, it might have been administering it before the Constitution came into force. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational institution provided it has been established by it. We're of the opinion that nothing in that case justifies the contention raised on behalf of the petitioners that the minorities would have the right to administer an educational institution even though the institution may not have been established by them. The two words must be read together, and so read the article gives the right to the minority to administer institutions established by it. If the educational institution has not been established, it cannot claim to administer. That's what Basha held, and I agree here. One. The judgment of the Allahabad High Court, which is under challenge in the present appeal, rejects the prayers made on account of the decision of this court in Basha. The issue arising in Basha, Supra, was referred to a 7-judge bench by an order of this court on 26 November, which is Justice Fazal Ali's order, which is writ petition so-and-so. The aforesaid writ petitions were heard along with other connected matters in TMA Pi by a bench of 11 judges, and the judgment in cases reported in so-and-so. Question which was formulated for answer in TMA Pi, which coincidentally reflects the questions referred to by order of this court of 26 November, passed in writ petition so-and-so. What are the indicia for treating an educational institution a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by persons belonging to a religious and linguistic minority, or it's being administered by persons belonging to a religious or linguistic minority? However, the bench did not answer the question, stating that it will be dealt with by the regular bench. The order of the regular bench passed on 11th March, which for reasons that we need not dilate, did not answer the aforesaid question. The said facts would show that the correctness of Basha arising from the decision in Basha has remained undetermined. That apart, the decision of the court in Yashpal and the amendment of the NCMEI made in the year 2010 would also require an authoritative pronouncement of the aforesaid question formulated, besides the correctness of the view in the judgment of this court in Basha, which was been extracted above. Ordinarily and in the normal course, the judicial discipline would require the bench to seek a reference of this matter by a 5-judge bench. However, being regard to the background as stated above, when the precise question is already referred to 7 judges and was, however, not answered, we are of the view that the present question set out above. So we referred to set out above. What is that? So clearly, Malaj.
Mr. Sibal, Justice Gogoi has referred to in the referring order, Chief Justice Gogoi's referring order, refers to 2 aspects.
Yes.
One, the correctness of the decision in Basha has been undetermined, has not been determined.
Correct.
Second, question 3A, which was framed in TMA 5,
Right.
was not answered.
That's correct.
So that's why if you will just revisit that once observation there, para 9.
Yes, that's the one. Malaj.
Para 9.
That's the one. Amendment to the
Para
NCM.
8 actually will see
Para
first.
8, Malaj. The said facts would show that the correctness of the question arising from the decision in Basha has remained undetermined.
Now we'll go to para 9.
Then 9. That apart, the decision of this court in Yashpal and the amendment of the NCMEI made in 2004 and made in 2010 would also require authority to pronounce on the aforesaid question formulated as set out above, besides the correctness of the view in Basha. Now, Malaj, my answer to your lordships is very simple. If your lordships decide that Basha was wrongly decided, nothing else arises. Nothing else arises. Yes.
3 questions which Justice Gogoi had in his mind.
Yes.
1, the correctness of the decision in Basha.
Correct.
2, question 3A, which was referred to in item 3A.
Yes.
In fact, he says that 3A covers the correctness of the entire decision, the 26/11/81 order.
Correct. Correct.
And 3, the impact of Yashpal.
Correct. Now, Malaj, as I said to your lordships, and I'm saying it time and again, if you hold that it was established by a minority, then nothing else arises.
23 now.
Sorry?
9 talks of both the things.
No, I know, but I'm on another point. Your lordship is right. I'm not disputing that, Mullahs. My request to your lordship is, yeah, assuming, Mullahs, your lordship finds that Basha has wrongly decided and 1981 is unconstitutional, where does it leave us? Leave us nowhere. Then we'll still be a minority institution.
We have to rephrase the reference because keeping in para 9 of the order we have just read out.
Yeah.
Yaspal and 2004 Act amendment in 2010, both are required to be examined, and in what context? On the aforesaid question formulated.
Therefore, Mullahs, my request to your lordships is you first examine whether Basha is rightly decided or not. Render a judgment there. If you come to the conclusion Basha is wrongly decided, the second question need not be gone into. If you come to the conclusion Basha is rightly decided, then, Mullahs, in any case, the 1981 issue will have
They
to be.
say besides the correctness of the
Yes.
group. Besides mean in addition to.
In addition to. Therefore, Mullahs, we have to move, Mullahs, in a way, Mullahs, that in fact it decides the matter one way or the other. Then you can decide the 81 issue. If you decide against me on Basha,
All right, now what
Mullahs,
remains now, Mr. Sibal?
NCMEI Act, amendment to the NCMEI Act would require an authority, the amendment.
On the question formulated.
Yes. No, Mullahs, this is not the NCMEI Act.
That amendment.
Yeah, there are two
That is
parts.
the first question.
What are the indications?
Change the landscape judicially if something.
Now, Mullahs, actually, if you look at 9, Malaj, actually, we've not fully understood the way 9 is formulated. Kindly do read it 9 again. That apart, the decision of this court in Yashpal. Now, Yashpal dealt with bogus universities in one building. And the amendment to the NCMEI, what was that amendment, Malaj? Originally, university was excluded. Now, university is included. That's all. And how that amendment will impact the question formulated.
Mr. Sibal, also we have to bear in mind, I mean, with a little bit of experience, that when you refer a matter, you're not looking at the matter threadbare. Sometimes you are. Suppose we were to refer it to a bench of 9. Now we have heard it for the last, so we are now completely in season of all
the matter.
No, but what we are saying is normally, otherwise when you make a reference,
Yeah.
you refer on the basis of, without really much ado, without going into a very detailed consideration of the matter. Therefore, the words of a referring court never bind the court to which it is referred.
That's
because you are a larger bench,
Yes.
you have to reformulate the questions
Yes,
to
exactly.
bring finality to the dispute.
Exactly.
In so far, but at the same time, there are some parameters which you keep in mind,
Of course.
which is you can't go beyond the pleading. You are
Exactly.
answering basically a question of law.
That's correct.
Before
That's all that I'm saying, Malaj. Even this amendment, it says to the, would also require an authority put on the aforesaid question formulated. What is the aforesaid question formulated? Whether Basha is rightly decided or not. Oliver relates only to Basha.
But Mr. Sibal, equally, just as you are saying, don't freeze Basha in point of time. Look at the law laid down by our court before Basha
Yes.
and after Basha.
Yes.
Because rightly, you've also relied on Stephens and, the TMFI.
No, that's it, a declaration of the law from the beginning.
Likewise, we can't freeze our version of whether Basha is correctly decided without reference to the entirety of the statutory history governing AMU.
But
We can't say we'll freeze it as of the statutes as in existence one day before Basha was decided.
that's
that
not-
cannot be a,
No.
that cannot be a correct approach for
The point is, Malaj, the 1920,
We have to look at the overall lay of the statutory scheme in relation to AMU.
Malaj, which we have placed before you.
Yes.
We have placed before you. We are not questioning anything that happened after that. Only reaffirms the fact the 81 only said that it was a minority institution. Now, whether that was right or wrong is a separate issue.
That's your argument and that's your point. That look, even if you were to look at the 81 amendment, 81 reinforces
Yes,
what according to you is the correct position even before 81.
That's right. So, Malaj, therefore, you can look at
And
it.
we'll
And
judge
if you
on
decide
that.
against us, Malaj, then that question will arise. So, Malaj, let me quickly now finish with this, Malaj.
Yes.
Now, having said that, Malaj, kindly now see what Basha decided. So we know we've done that. Now, Malaj, what are the correct statements in Basha? Kindly look at factual aspect, Malaj, so that I don't waste your lordship's time. Kindly come to page 9 of volume 3A. Yes, it says, kindly see placitum A and B, statement of fact. Further, it seems that the existing MAO college was made the basis of the university and was made over to the authorities established by the 1920 Act for the administration of the university, along with properties and funds attached to the college, the major part of which had been contributed by Muslims through though some contributions were made by other communities. This is a factual statement, Mullahs? Correct. Nothing wrong with that statement. It only shows what? That we are the ones who set up the university. And Mullahs, that 30 lakh today, if translated today, into 2006, as translated, it would be 280 crores. And today it'd be 500 crores. So, Mullahs, Basha accepts. Is the MAO college was in existence. It was made the basis of the university. And whether the properties and the funds attached, that means everything in the college was handed over to the university. And the section itself says so. So the genesis of it is correct. That Basha affirms. Now, so it was, now number 2 is come to page 14 now. I'm just, Miller's indicating the facts that are accepted by Basha itself. It says, that brings us to the end of section 19, sections of 1920 Act. Your Lordship has, sorry, it's not that. Page 14. Yes, kindly. The next paragraph between B and C, Malad, sentence starting, the annexure to the 1920 Act. Lordship has that? Between B and C at page 14.
Yes, the last
The
sentence.
annexure to the 1920 Act gives the names of the foundation members of the court 124 who were all Muslims and who were to hold office for 5 years for the commencement. So, the factual statement, correct, indicates the genesis. Then come to page 15. Third paragraph, fourth line, between classitum C and D. It is remarkable that though the proviso to 23(1) was deleted as far back as 1951, there was no challenge to the 51 Act till after the ordinance of 65. Actually correct, Malad? Nobody challenged it. The reason for this might be that there was practically no substantial change in the administrative setup of the 1920 Act, and it is only when a drastic change was made by the Ordinance of 65 followed by the Act that challenge was made not only to the 65 Act but also to the 55 Act, insofar as it did away the proviso of 23(1). So factually, Pasha acknowledges that nothing changed, despite the 51 Act. Acknowledges that fact. And what was the proviso? That all members of the court shall be Muslims. That's the third factual issue. Fourth, page 16, top of the page. The statutes was right, placetum A. May I read it? The statutes were also amended and many of the powers of the court were transferred by the amendment to the Executive Council. Further, the constitution of the court was drastically changed by the amendment of the 8th statute, and it practically became a body nominated by the visitor, except for the chancellor, the pro-chancellor, the members of the Executive Council, who were ex officio members, and 3 members of Parliament, 2 to be nominated by the Speaker of the House, and 1 the chairman of the Council of States. Changes were also made in the constitution of the Executive Council. Finally, the 65 Act provided that every person holding office as a member of the court or the Executive Council, as the case may be, immediately before the 20th day of 65, shall on and from the said date cease to hold office. It was also provided that until the court and the Executive Council were reconstituted, the visitor may by general or special order direct any office of the university to exercise the powers. So this tells you, this is the reason for challenge of the 65 Act. Correct, Malad? That's why it was challenged. Now come to page 17, top of the page, placetum A. Yes. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational institution provided it has been established by it. So that's the statement of the law, provided we have established it. So that's correct also. Then 17, at page 17, placetum F. We have therefore to consider whether Aligarh Muslim University was established by the minority community, and if it was so established, the minority community would certainly have the right to administer it. So clear, Malads? That's what they say. So test is only of establishment, nothing more, and at the inception. Correct? So that's page 17. Then come to page 18. No, before we do so, the placetum paragraph starting before we do so. Before we do so, we should like to say that the words educational institution are a wide import and would include a university also. Please, mothers, mark that. That's the contradiction in Basha. Kindly see, I'm sorry, I should have read the first paragraph. We shall have to examine. We shall have to examine closely what happened in 1920 when the act was passed to decide, firstly, whether in the face of that act, it could be said that the Aligarh University was established by the Muslim minority. According to me, a wrong question asked, and you got the wrong answer. He says, if by virtue of that act, can you say that the university was established? And that's the answer he gives. So we shall have to examine what happened in 20, when the 20 Act was passed to decide, firstly, whether in the face of the Act, it could be said that the Aligarh University was established by the Muslim minority. Secondly, whether the right to administer it ever vested in the minority. It's also wrong. I've shown to your lordships the provisions. Court was all Muslim. Money was there. Executive Council, Academic Council. In the Executive Council, out of 30 members, 23 were Muslim. That's administration. In the Academic Council, the majority were always Muslim. That's the administration. And three, even if the right to administer some properties that came to the university vested in the minority before the establishment of Aligarh, whether it had surrendered when the Aligarh University, what does that mean? Surrender means what? Whereas if we want to become a university, we'll have to transfer all rights and obligations to the university. There is no other way to become a university. So where's the question of surrender? By virtue of the statute, to be called a university, we have to transfer all rights and obligations of property, teachers, students, everything, which is exactly what we did. Then, before we do so, we should like to say that educational institutions are a wide import and would include a university also. This was not disputed on behalf of the union.
University is an educational institution.
That's right, not disputed. So it comes under 30 sub-article 1. That's the point I was making, Madam. Union of India, and therefore it may be accepted that a religious minority had the right to establish university under 30 Article 1. The position with respect to the establishment of universities before the Constitution came into force in 1950 was this: there was no law in India which prohibited any private individual or body from establishing university, and it was therefore open to the private individual or body to establish university. There's a good deal in common between educational institutions which are not universities and those which are. Both teach students and both have teachers. But what distinguishes a university from the other is that a university grants degrees of its own while the educational institutions cannot. Then come back, Malas, this is what he said. Now, Malas, kindly come back to H. Tacitum H. The importance, kindly see. Last, just above H, the importance of the recognition of government in matters of this kind cannot be minimized. The position continued even after the Constitution came into force. It was only in 56, and that's the 22 that your lordships referred to, my Lord Justice Suryakant. Then kindly come to page 19 at the bottom. Tacitum H, it is true. 19 words, it is true, as is clear from the 20 Act, that the nucleus of the Aligarh University was the MAO College. Kindly see, Maharaj, these are all acceptance of our facts.
Where is that? True. What is the, which is that?
Page, Maharaj, 19 at the bottom, right. Last paragraph. These are the contradictions in the judgment. It is true that, let me read it. It is true, as is clear from the 20 Act, that the nucleus of the Aligarh University was the MAO College, which was till then a teaching institution under the Allahabad University. The conversion of that college, if we may use that expression, into a university was, however, not by the Muslim minority. What does that mean?
What it says basically is a new institution which has come up.
Naturally, Maharaj, there is no other choice in the matter.
Then we'll see how it was incorporated.
It took place by virtue of the 20 Act, which was passed by the Central Legislature. There is no Aligarh University existing till the 20 Act was passed. It was brought into existence by the 20 Act. This is the logic. So because it was brought into existence, it loses its minority character.
Now, page 20 at Placid, between A and B, it says it was brought into being by the 1920 Act and must therefore be held to have been established by the Central Legislature, which by passing the 1920 Act incorporated it.
That's right.
This follows the provisions of the 1920 Act, which said to establish and incorporate.
Correct, absolutely.
That's where they get this.
That's where they get it.
So to that extent, they are right. The 1920 Act said that the Act is establishing and that it is
But
incorporated.
Manoj, it doesn't matter because you can establish and incorporate being a minority institution. It doesn't answer that question, Manoj. Any number of statutes now which do that even today. You are incorporated.
University should be brought into existence.
Who determined?
Who determined? Ultimately, when
The
the
Act.
act
Yes, that's the question.
legislature,
Of course, the legislature determines the university community, and the conditions are, what are the conditions? That you must have this amount of area, you must have this amount of student teachers, there's be an executive council, there'll be a structure, all that, that's the 1906 conditions. Those are the regulatory conditions. But the choice to set up a university is mine. Now, did the minority set it up or not is the question.
Mr. Sibal, if you come to page 19,
Yeah.
there is one paragraph which is
Yes,
worth reading.
yes,
There was nothing in 1920, the sentence starts like that.
yes, 1920 to prevent the Muslim community, if it so chooses, correct, I'll read it, Mullah, to establish a university. But if it did so, the degrees of such a university were not bound to be recognized. So where does it take us, Mullah? What's the use of having?
Therefore, in order to get the degrees recognized by the government,
I had to.
you had to approach. the
Correct,
government.
but that doesn't mean it was established by the government, by the government. That's the question, Mullah. I had no choice in the matter. If I want to be called and to be a university is my right under 30. And the nucleus came from the college and the property and everything. So the question is, I can't be a university. To be a university is my right under 30. That also Basha accepts. This is the problem.
Probably that
Sorry?
even it was not disputed before the bench that even before 1956 Act,
Yes,
the degree could be awarded only by a university,
absolutely.
and that university must be recognized by the government. Then only that degree.
That's right, absolutely. No doubt about it, Mullah. That's
Legal
right.
position.
In other words, Mullah, if my right exists under 30 and I get it incorporated, I lose my right under 30. That's what it comes to.
I think we're just understanding the logic of the court. What they are saying is that a educational institution includes a university. Aligarh Muslim University, in its character as a university, is established by an act of the Central Legislature. And because it is established by an act of the Central Legislature, notwithstanding all the efforts which were made by the Muslim community for, sort of in the movement to set up the college and then convert it into the university, the establishment is by an act of the legislature and not by the Muslim
All right,
community.
but let me answer.
That's the logic.
Correct,
which
but
we
let me
find
answer
in
that straight away.
Yes.
The word established in Article 31 is different from the concept of establishment under an act. I answer that straight away. Establishment under an act is the recognition.
Just one.
Yes. Word established in 31 has a connotation, 30 sub-article 1 has a connotation which relates to the genesis of the institution, whether it's a college or it's a university or it's a school. Establishment in the statutory sense is the recognition for incorporation to grant a degree. So these are two separate concepts. We can't confuse the word establish in the context of one with established under Article 30, sub-Article 1. There your lordship is right, that in that sense, that word establish is used in the incorporation sense. But today, for example, you want to set up a university, you have to go through the same thing. It's a minority university, you go through the same thing, but it doesn't destroy your character as a minority university.
The minorities by themselves do not have the right to create statutorily a university.
Yes.
They have to go to the
You
authority.
have no choice, mother. That's 1906. That's
For that
standard.
matter, any individual doesn't have.
And 30 recognizes your right to found a university also.
That's right. That's accepted even in Basha.
And the only, to establish, yes, to establish a university.
The word
But
established.
the only statutory way of doing it is to
That's
go through an act of
That's
parliament.
right. And that concept of establishment can't
That's
be confused because it's used in two separate senses.
Mr. Sibal, we are on the verge of the stroke of lunch. The bales are about to be removed.
Mother,
Avi,
what
now,
happens is
start
sometimes
with
the
your
ball is bowled and the base don't get removed, mother. So therefore, please wait till 2 o'clock. I'll finish very soon.
All right.
Deeply obliged. You're also been very kind.